Hi everyone, my name's Mark Bowden. This is my first video. I thought to start off with a very topical subject, which is the General Data Protection Regulation, GDPR, or as it's incorporated into UK law, the Data Protection Act 2018, 338 pages. It's very topical at the moment because under COVID track and trace, lots of hospitality businesses are now having to record data about their customers. Many of those businesses will already have experience handling personal data, but many others, such as pubs, maybe would not. It's obviously important that all the businesses are required to comply with track and trace, but they've got to do that in a way where they're also compliant with other aspects of the law, in this case GDPR. So I thought we'd just start this one off, and this will not cover all aspects of GDPR today because it's quite a massive subject, as you can see from the thickness of the legislation. But we'll start off with a couple of sort of high-level things. So the first thing is what do we mean by personal data? So personal data is data about identifiable individuals, which might seem obvious. Living identifiable individuals, in fact, specifically. The issue, though, comes in terms of what we mean by identifiable. So someone's name, address, date of birth, I think we all agree that's identifiable information. But it gets a bit more complicated because actually under the definition in GDPR, any data which, when combined with another piece of data, makes it possible to identify an individual is classed as personal data. So it might, for example, be a ticket number or a receipt number, which in and of itself is just a number, but if you combine that with the register showing which customers were actually using the establishment, you'd be able to identify, cross-reference and look up a name and address. The problem with the data that's able to identify a customer in combination with something else is that, of course, you can sort of go on and on with that and think, well, what else could you combine almost anything with? Could that be enough to get actually a personally identifiable individual? So you have to really treat all of this data very, very carefully. So that gives a sort of high-level view, and I would absolutely recommend, by the way, that you look at the Information Commissioner's Office website. There's some very, very good, very clear definitions on there, and I'll put a link in the comments. But if that's what personal data is, let's just summarise the 7 principles of GDPR that you need to comply with when you're processing that data. So the first one is that you actually have to have a lawful, fair basis to process the data. So if we think about COVID track and trace, for example, that's not really an issue. You're being asked by another piece of legislation to record that information. That clearly gives you a lawful basis to do it. So that one's probably fairly easy for many businesses to tick off. So that's good. Purpose limitation, the second principle. Now this one is where you need to be a little bit careful you don't come unstuck. So the data's been provided for a purpose. The purpose is obviously for COVID track and trace. Fine. But you cannot use it for other purposes. So let me be completely clear on what I mean by that. You cannot take the list of customers who have come in to your pub, restaurant, cafe, whatever, use that list to create a mailing to go out to them and offer them a discount for their next visit. You cannot do that. They did not provide the data for the purpose of you using it for marketing. You may separately ask them to confirm, and we all get very used to seeing this on the internet, that they consent to you using it for marketing, but you must ask them. It is not the purpose for which the data was provided, so you cannot presume consent. The third principle is around data minimization. And this is also another place to be really, really careful you don't come unstuck. So data minimization is the principle that you can ask for the data you need to do the task you're doing, process the transaction, book the table, whatever it might be, in this case track and trace. And there's some very clear information that you need to record under track and trace, name and contact details. You cannot collect additional data over and above that. So you could not, for example, ask them to bring in a utility bill and to prove their address and keep a copy of that utility bill on file to go with the record, because clearly that's got all sorts of other information that's way in excess of the purpose, and that breaches the data minimization principle. The fourth principle is accuracy. So you must take all reasonable steps to make sure that you do not hold incorrect or out-of-date data. You need to correct data as soon as is reasonably possible in the event that you are notified that it is incorrect. So, important, you get the details, you make sure they're correct. If the customer notifies you that they're incorrect, you must amend them. Really important. Storage limitation. You must not keep the data longer than you need it. Now this, to me, is one of the biggest risks I can see out of all of this. So under track and trace, you are required to hold the data for 21 days. So on day 21, at the end of day 21, you must delete, destroy all of that data. You can't do it on day 22 or day 23, or stick it in a file and hope for the best because you think the customer's going to come back in tomorrow. Even if you know the customer's coming back in tomorrow, you cannot keep their data from their previous visit because they have not consented to you keeping it, and the requirement is to hold it for 21 days. So it's super important, you must dispose of it. The next principle is integrity and confidentiality, which sounds a bit fancy. Really what that means is security. You've got to keep the data secure. So if you're holding it on a computer system, that's got to be adequately password protected. It's got to have appropriate access controls and audit trails to make sure that it can't be accessed, and if it is accessed, you know who did it. It also needs to be disposed of securely, so you can't just dump the disk outside, dump the computer outside. So that's important. But the other aspect of GDPR that's worth considering at this point is, you might be thinking right now, actually, hey, this is all really difficult. Why don't we just write it on a piece of paper? That's got to be easier, right? The problem with that is that actually GDPR is not about electronic records. It's about information that your business holds, personal information that your business holds. So if you decide to go down that route and you choose to keep all of this data in paper format because you think that sidesteps the issue, it doesn't. It's all in scope, and you've just created yourself a monumental headache around then the integrity and confidentiality requirement, because actually you've got to keep all that data under lock and key in a filing cabinet. Okay, that maybe doesn't sound too hard. What are you going to do when you have to get rid of it? You have to securely destroy it, and that means probably securely shredding it, not just chucking it in a household shredder, or even worse, just dumping it in the waste bin. It needs to be securely destroyed. But of course, if it's on paper as well, it's much more difficult for you to know actually who has accessed it, because who's to say that when the filing cabinet was opened, someone hasn't whipped a sheet out and just taken a look and jotted some details down maybe. How do you know it's actually been destroyed? How can you prove it's been destroyed? Much more difficult than actually with an electronic record, where you can have an audit trail that shows who's looked at it, and you can actually demonstrate that that record has been destroyed. And better yet, for most electronic systems, you can have it automatically be destroyed. The seventh principle, which we haven't come onto yet, is accountability. So the point about accountability is you must actually keep appropriate records, and you must have the right measures in place and be able to actually demonstrate that you are complying with the other elements of the Act, the other 6 principles. Now, one of the ways you can do that with electronic data in particular, you can do it with paper as well, is you can have logs showing what records you keep, what the retention schedule is, i.e. when you're going to delete that data, and you can have a named accountable person. In fact, you should have a named accountable person who is responsible under law for the correct handling of the data. So that's really what the accountability principle talks about. That's a bit of a both whistle-stop and condensed tour of parts of GDPR. I will talk on another video about the rights that GDPR confers to individuals. The most important one of which is the right to access your data. I'm not going to talk about it enormously now. As I say, I think that warrants a subject all of its own, except to say that any individual has the right to request that you provide any information you hold on them at any time, and you have 30 days to comply. So that's something to absolutely have in front of mind, that all of this data that you're collecting here, actually the customer has the right to see as well. So you know, double reason really to be cautious about what you hold. So that's kind of all for this session today. As I say, there will be further videos to come. I hope you found it useful. If you have, pop something in the comments below. If you're interested, we do more detailed one-to-one sessions around GDPR, and you can check those out via our website at cobaltbeach.com. Otherwise, I hope to see you next time. Thank you very much.